All right, why don't we go ahead and get started? I'm going to start off by introducing our panelists. And originally, when I wrote this talk, I said I would keep it brief, but we've actually lost one of our panelists. Unfortunately, Dean Shafson couldn't join us today because of a family illness. What does that mean? That means that I get to do a longer introduction, right? Okay, so I was going to say we're here on this second month, on the 22nd day of the year, 2/22. That's probably enough twos for the day, right? So, yes, that was a two joke, and I find that it helps to explain the joke 2 or 3 times to really get it through, right? All right, so I'd like to introduce first Dean Sundquist. He's the Director of Faculty and Research and Scholarship at Albany Law School. He's a leading national scholar on the issues of technology, race, and innovation. Dean Sundquist straddles 2 fields. He has a joint appointment with both law and psychology. He received his BA from Carleton College and his JD from Georgetown University. Dean Rooksby is the dean at Gonzaga University School of Law. Appropriately for this conference, he straddles both law and education. He holds a joint appointment in both the College of Law and the College of Education. He's the co-author of the 6th edition of the Law of Higher Education. He has an AB from William and Mary. He has a JD, a Master's of Education in Social Foundations of Education, and a PhD in Higher Education, all from the University of Virginia. My goodness. So I have a quote from Oliver Wendell Holmes, which says, 3 generations of law degrees is enough. I modified that quote for my own purposes. And just to quickly introduce myself, I'm Professor Tu, the Associate Dean for Faculty Research and Development. I also straddle 2 disciplines, my first love being biochemistry and my evil mistress being the law. All right, so like Dean Rooksby, I write in the area of in the area of intellectual property, and like Dean Sundquist, I also do or try to pursue grant-funded interdisciplinary research. It's interesting that between the 3 of us, we have 10 degrees and over 30 years of, I think, postgraduate education. So if nothing else, we know something about being a student. So I guess I wanted to start this panel off by painting a picture for you guys. And we're going to do things a little bit differently from the morning sessions because I think a lot of people in the audience are law students, so I want you guys to really interact with the panelists. So I'm going to open it up for questions towards the end, and I hope we get a lot of questions from students. I'm going to paint a picture for you guys, a picture that I'm very familiar with because it's my own story. When I entered the profession right out of law school, I joined a top 200 law firm that was the top law firm for prosecuting and litigating biotechnology patents. With my newly minted law degree, I was feeling pretty good about myself. The starting hourly rate that my firm billed me out with was $350 an hour. And at my first assignment, at the first week of work, I was given what was called a restriction requirement. This is a patent law term. And it's basically saying, you got 2 inventions here, pick one. Because we're only tasked with, you paid us 1 fee, we're only going to examine 1 invention. And I got this sheet of paper, and I was like, this was my oh shit moment, right? I said, oh shit, my God, what have I done? Because I have no idea how to respond to this thing. So that, and I realized, for the first time in my life, I've only seen 1 patent ever, and it was copied into my casebook. And at that moment, I realized, I definitely wouldn't pay me $350 an hour to do this kind of stuff. So what did I do? I looked at, more than half a dozen restriction requirement responses from our internal document search, and I wrote this brilliant 6-page response to the restriction requirement that explained the 17 reasons why the examiner was wrong and why we should not have to we shouldn't have to choose between these 2 inventions. A few weeks went by, and I looked at what the partner actually filed, and it was, "We choose invention number 1, period." Signed off. So I look back at my first few months, and it took me hours to complete tasks that should have taken me minutes. I lived in fear that I was going to mess things up for my client. I lived in fear that I would mess things up for my job and myself. I was told not to cut my time, so I didn't. I'm sure my supervisor cut most of my time, so that 6-hour document probably was what we call a .2, which is 12 minutes, right? However, this was an exciting time in my life, and I learned so much on the job. In a firm of over 1,500 lawyers, I was told that I recorded the most hours. But with that said, I wasn't even in the top 100 for billable hours. So bottom line, I was not practice ready, and I don't think this is an uncommon story for a lot of our students. So legal education has really become too expensive in time and money for anyone to accept the proposition that law school quality is just simply a function of test scores and the students we admit. We say that our job as academics are to teach students how to think like a lawyer, but that's not enough in this economy. We have to teach students how to act like a lawyer, how to write like a lawyer, how to litigate like a lawyer, how to practice like a lawyer, all this while also trying to teach students how to build a client base like a lawyer, how to become a rainmaker like a lawyer, and how to succeed as a lawyer. I will tell you, this is an impossible task to do in 3 years. However, to justify our current price tag, a law degree needs to be a transformative educational experience that confers both personal and professional benefits to the students and positive external benefits to society in the form of more capable leaders and problem solvers. So the real question is, how do we pick and choose those areas that give us the most bang for our buck? So the question that I pose to our panelists is threefold. One, in a world where we still bill by the hour, which is one that rewards inefficiency, and in a world where firms don't want to train their young associates, mainly because their billing rates are too high, how do we as legal educators address some of these issues? All right, so the threefold question is, one, how do we define the problem of practice-ready lawyers? What is the problem? What is the scope of the problem? And what is outside the scope of what law school should do? Help me determine what the scope of what practice-ready means. What are the most, so that's the first element. The second element is what is the most common issues that you see as far as failures by law schools to create practice-ready lawyers? And then third, what do you think some of these solutions might look like to creating practice-ready lawyers?
I'm going to pass.
Okay. All right, so why don't we start with Christian then?
Okay.
I was just kidding.
Yeah. Now, I was writing all three questions down, as any good student would. So how do we define practice readiness? That is a fairly controversial issue in some ways. I think one primary critique is that some schools, certainly not West Virginia, might use that term as a way to transform legal education into something akin to a trade school, right? Vocational learning and the like. Obviously, there are many counters that we're trying to abide by ABA guidelines. We're trying to follow broader structural forces in providing more practical value to students. And so my conception of practice ready is more aligned with figuring out what we can do to help students become profession ready in a rapidly changing legal landscape, right? And so I'm going to echo some of the comments made by Governor Wise in his remarks. We need to think about what students need to learn moving forward for the next 5 years, for the next 10 years, for the next 20 years. And so, at least from my perspective, we need to not only expose students to those very important practical skills, which hopefully many of you are taking advantage of a clinic offered here, or externships, or internships, or other experiential opportunities, but also identify what we can be doing better to help students become lifelong learners of the law and stewards of the law generally.
So it's good to be back in Steelers country. I used to live in Pittsburgh, Steelers. I'm out west now where they don't root for them. I think Professor Tu's comments to open this panel were instructive because I had a very similar experience. My practice background, starting out of law school, was at a large firm, McGuire Woods, and I remember writing down my time, and my boss came in early on and said, what is this? I said, well, that's my time entry. And we had never discussed time entry in law school, okay? And I had written something like, point 2, search endlessly for case law that supports clients' facts, couldn't find it, kept searching, something like that. And he said, whatever you put here goes presumptively on the client's bill. You know that, right? Unless someone like me catches it. And I said, no, I didn't know that. Where would I have learned that? Law school, presumably. And, that's just one example of the day in, day out kind of skills that lawyers need that I think law schools historically have not done a very good job of teaching. And again, we should preface our comments. We're, of course, not talking about our law schools or this law school. We're talking about law schools generally, those hypothetical
all the other
entities. But I think the larger problem that I see, and something that you said sparked this thought, you mentioned that we're not vocational schools, right? And that's true, but we are, I think, it's without question, we are professional schools, which is very different than graduate schools. And yet, the whole history of legal education, I think, in the last 100 years has been built around this concept that law schools should be like graduate schools. In fact, in the halcyon days of the 80s, 90s, into the early 2000s, that's why a lot of people went to law school. They didn't quite know what they wanted to do in life. And it was seen as a very elegant, advanced liberal arts education. And for many professors, it was seen as, I want to be a professor. It's better to be a law professor than an English professor because law professors make more money. So let's pursue this field. And I think that's had some unfortunate consequences for our profession and what we do in law schools because the notion of practice readiness is viewed by some as icky. It's viewed by some as beneath them. And I have a lot of comments on that. I don't know if I should keep going on that thread or if I should cede ground. But it turns on what we're looking for in professors, right? What is an ideal law professor? And this is something that's I've given a lot of thought to most recently in my role as dean, but even prior to that, getting hired as a law professor and then being on our hiring committee at my previous institution for many years, seeing how that market works and what's prized in that market. And what's prized in that market really is scholarship, pure and simple. There's lip service paid to teaching potential or evidence of teaching capability. Some come in with it, some don't. But if you have really well-placed articles, we'll pretend that you're going to be a very good teacher. And that may or may not be the case. But what's missing from the discussion usually is, does this person understand the actual practice of law? And where is the evidence in their resume that would suggest that? At the most elite schools, it is the model that they hire professors usually right out of a series of clerkships. The clerkships tend to be appellate clerkships. And not that you don't learn something about the practice of law in those, you do, but it's very different than actually representing a live client when the deadlines are real and the problems are yours. And so I have a real bias when hiring in looking for professors that I think are, triple threat players. They can teach, they can write, and they know something about the practice of law, and they respect it. I always say to people, because I'd occasionally meet people like, why'd you leave the practice? I said, I didn't leave the practice because I didn't like it or I wasn't good. I just wanted to teach also. But I think we all know colleagues for whom that's not actually the case. They didn't practice or they didn't like it or they weren't good at it. And they become law professors because you don't have to practice anymore. But yet we are a professional school, and I think we should own up to the fact that we are not training future law professors by and large. We're not training people to go on to teach. We're training them to go out and practice. So we should have a real concern for how we're doing that, and we're doing it in the classroom. So I think the ABA's recent focus on experiential learning is long overdue. It is, in my view, appropriate that we embrace these forms of learning, but we're not doing it enough in doctrinal classes. And we're not doing it because often doctrinal professors are not well suited to integrate experiential learning or real-world learning into the classroom. So I always say, you've probably encountered many people in practice, those of you in practice may have this view, where you hear them say, well, that's what you learn in law school. But let me tell you here, out here in the real world, this is how we do things. And, it's like these two worlds exist, and they don't overlap at all. But I think law schools should ask, why is that, right? Why can't we not move those two closer together? It makes sense if we're just a graduate school that what you learn is what you learn in law school. But if it's a professional school, there actually should be some hand-in-glove handoff that's going on between what you learn and what the real world is like. And can't we imagine a world where somebody says, I'm prepared for this because this is what I learned in law school. Actually learned this in law school. Timekeeping. I'm still aware of law schools that either, they may keep time in clinics and other things like that, but they don't actually do it in a real way, right? Because they're not actually using the software, the timekeeping software that real lawyers use. They're using things like Excel spreadsheets or just writing it out longhand and handing it in to someone. That's not what many attorneys do at medium-sized to large-sized firms. They use software, but the law schools don't have it. Some might, but not all do. So, if we really are truly thinking about valuing skills training, I think we have to fold into that how we hire and what we prioritize for faculty. And one more thing, and I'll stop talking. But when I was on the faculty at Duquesne, I taught torts, I taught intellectual property law, and I did that for 3 or 4 years. And I was having lunch with a local attorney in Pittsburgh, and he said, this is part of the discussion, you seem like somebody who you practiced before, why'd you give it up, that sort of thing. He said, would you ever think about doing it again? I said, yeah, absolutely. I would love to think about doing it again. Long story short, I became of counsel at a firm, Cohen & Grigsby in Pittsburgh, and I started up a practice. Most people who are up of counsel, they're winding down a practice. I was starting up one in my mid-30s at that point. And it was the most rewarding thing I did because it reintegrated me into real-world problems in the areas in which I taught. And so I would be teaching torts in the morning and then at one point doing a deposition in the afternoon. And I became a better professor because I did that. And I was not too long out of law school or too long out of law practice at that point. And so I'm thinking, why do schools not encourage that more? And there's a history where there's a problem, right? Because you go back, decades ago, some people were just moonlighting as professors and were really just full-time practitioners. But can't we find that balance in some way and find a way to reward or incentivize that balance?
Excellent. Thank you for those comments. I unlike Professor Rooksby, would not go back into private practice. No way. Could not pay me enough money. Dean Sundquist, could you comment also on kind of what you see as the main problems with creating practice-ready lawyers and how we might be a little bit better positioned to try to address some of those problems?
Right. I mean, that's a huge issue and a huge question, and I think many people here would have different viewpoints. From my perspective, I think a lot of what was said earlier is absolutely true. There is some reticence amongst law faculty to change how they approach legal instruction, how they approach the material in a doctrinal class. But I also think that law schools have been fairly slow to shift from that traditional Langelian case method approach to legal education. We're seeing some innovations. We're seeing some innovations here in West Virginia, in Albany, and Gonzaga, I assume, and all the other great law schools. But I think what we need to see is additional focus on trying to identify, again, those skills that students are going to need, not only when you graduate in 1 or 2 or 3 years. I'm not sure how many 1Ls are here, but there are a few 3Ls are in the present at the moment, but also what skills you're going to need in 5 years or 10 years. And your dean wrote a really interesting article, I think it came out earlier this year, that essentially posited we need to think about what that creative law school of the future looks like, right? What does it mean to teach our students to have innovative skills? And at least from my perspective, technology is driving a lot of this change, right? So we have IBM's ROS system, which purportedly can reduce the number of hours junior associates spend on a matter by 30%. We have this JP Morgan coin artificial intelligence system, which supposedly can review documents in a few seconds, which ordinarily would take 360,000 associate hours to review. And I forget what your billing rate was, but that's a lot of money, right? And so many other transformations in the legal industry right now that are driven by technology. So even though I think it is critical to retain some aspects of what we have been doing historically in terms of teaching the law, you need to learn legal basics and so forth, I do think this new legal model moving forward needs to be based on critical analysis, on interdisciplinary creative problem solving, on innovation, on emotive client-based lawyering, where a focus is placed on your emotional intelligence. In other words, those skills, those attributes that will not be easily displaced by artificial technologies of the future.
I couldn't agree with that more. I graduated law school in 2007, and the first large case that I worked on was a bet the company patent infringement lawsuit. And it was actually pending in Abingdon, Virginia, and it involved Purdue Pharma. That was our client, makers of OxyContin. And they had been sued by another manufacturer, King Pharmaceuticals, for patent infringement. And I was the lead associate, junior associate on the case. My partner was the partner in charge. And document review and production was a big part of the case. Each side produced over 1 million pages of documents in that lawsuit. And I'll never forget it. It was a formative experience for me. I was literally, fresh out of law school by the time the case ended, 2 years out of law school. Felt like it was 2 years of my life, maybe longer. But in order to get all the documents reviewed in time on the discovery timeline, we hired a team of contract attorneys. And this was late 2007, 2008. This is when large law firms are dismissing partners and entire practice groups. And we had, at one point, 70 contract attorneys that I was overseeing reviewing documents, and I was reviewing documents as well, mostly just hot docs, which is not as exciting as it sounds. But I went to New York City to train these contract attorneys, and many were 7th, 8th year associates from Skadden and all these big, large law firms. And they had gone to places like Harvard and Yale, and now they were getting paid by the hour to review documents, and they weren't happy. And I was shaking in my booties because I was this junior attorney, and I had to go up there and train them in what they should be looking for. And I remember the in-house IT, information technology professional at Purdue Pharma said to me, and he said, you lawyers, you're going to be out of jobs soon. I go, what do you mean? And he said, there's something that you think is special when attorneys' eyeballs look at documents, like something special happens. And I go, what do you mean? He said, we could have a machine do this. And it's not going to be too soon in the future where machines really will do this. And then now what are these 70, 80 attorneys going to do? And I thought, well, you may be right, but I can't solve that problem at the moment. And I think back now, and I talk to people in large law firms, and they're not hiring, teams of contract review attorneys. And in some cases, it's because, production parameters have changed, I think appropriately so there's not the same volume of material. But also, it's unavoidable that there's technology that can do this better, more efficiently than attorneys. So I think your point is well taken. We have to get out ahead of that curve in focusing on what is our unique province in legal education. It's not teaching people how to review documents. It's communication and expression, I think, are fundamental to what we do. Analysis is part of that. That's where we can beat the machines. And how do we model that? How do we focus on that in legal education in all that we do? I don't know that we're there yet. And I think there's some lost opportunities. I am struck, I've talked to students sometimes in their second, third years of law school, and they say something to the effect of, I don't really like to write that much. And I said, well, that's a problem, I hate to tell you. Because what was it that you thought you were going to get paid to do? We don't do open heart surgery, okay? What we do is we get paid to write, to think, and to speak. It's communication. It's fundamentally about communication. And so when I encounter professors, again, not at my institution, but I say, I don't really focus on the communication because I want people to get the material out. And I'm like, yeah, but isn't that preparing them for a world that doesn't exist? Because judges care about communication, clients care about communication, and just because you're not a legal research and writing professor doesn't mean you shouldn't care about communication. That is really what we can own because I think, for the foreseeable future, we're going to be able to write better than computers. We're going to be able to analyze and articulate better than computers, and so we need to own up to that fact in legal education.
So Dean Sundquist, what do you think we should be doing? Like, what are some tangible solutions to this issue?
Well, fortunately, I have so many answers, but no, I just have a few rough ideas, and I think this is a group effort, right? And so I do hope once we open it up to broader discussion that you'll not only have questions, but you'll have ideas potentially about what law schools can be doing better or differently moving in the future. I think first, I do have a few ideas though. I do think that we need to ensure that students have the ability to understand and also to utilize new technologies, whether we're talking about doc review technologies or otherwise, to provide legal solutions to clients. That can be difficult to ramp up. I certainly acknowledge some of the administrative costs in doing that, but I think it's critical to ensure that our students at least have some exposure to those new technologies that are being used in the field. I think it's also important to stress that students need to understand how legal information is being compiled and sorted and interpreted by these new technologies that are still very much subject to coding biases, perhaps unintended, but biases nonetheless. You think about, I'm not sure how many of you here have experience in coding at all, probably not many, otherwise you wouldn't be here, right? But it's a fairly simple concept. Let's take the example of, let's say a judge wanted assistance with figuring out how to employ sentencing guidelines, and they want to take account of the possibility of that the defendant might reoffend sometime in the future. So what factors would you code, so to speak, in that software program to allow that program to come to some conclusion or some suggestion to the judge as to how many years this defendant should be sentenced to, right? So you need to think about that. You need to, I think, criticize the underlying assumptions of much of this technology. Using that same example, there are a few software programs in use right now by many state courts. Predpol is one. There's another called Compass with one S, if you want to Google it after our talk, right? Not right now, but after our talk. And unfortunately, a review of the sentencing recommendations utilized by those state courts did find that the sentences that issued for non-white defendants were quite higher than the sentence recommendations issued for white defendants. In other words, if you check that one box that said black, your client would likely get a higher sentencing recommendation. So this is just a basic idea, right? So it's easy to be fascinated by these new legal technologies. I'm very fascinated by many of these technologies. I think they can have a lot of positive good in transforming legal practice and transforming legal education, but you have to critically understand what that knowledge base is and how it's being used. So I think that's one area in which law schools can do a better job. And I have a few other thoughts, but I think I've spoken a bit too long, or do I have time? I'll keep going a little bit. This will be pretty quick. And this is touching on some of the comments that have already been made, to engage in high-level critical analysis, right? The ability to develop, to understand, to articulate policy arguments. You already do that, hopefully, in many of your classes, to engage in complex oral advocacy. In other words, to have that experience communicating not only with your peers, but also with clients as well, and those opportunities need to be expanded to provide creative and innovative solutions to very complicated legal problems. What we're seeing right now is a lot of interdisciplinary work, so you're going to need to have those emotive and communication skills to work with non-lawyers sometimes, right? Maybe even folks who have an expertise in biochemistry or in areas that are frightening to you, and to work as a team to develop a solution to a complex issue that isn't solely legal in nature. And so those are some of the ways that I think law schools can respond to what's happening right now.
So Dean Rooksby, what solutions is Gonzaga taking to beat the machine?
Well, I've only been dean 8 months, so you got to give me a little more time. I will tell you some things that I think every law school ought to consider or ought to be doing. One, and this is, some of these are getting down into the weeds, and any dean or former dean will tell you faculty will only take so much in terms of suggestions for how courses should be taught. That's a whole nother issue involving academic freedom that maybe we can talk about, how to implement these things. Because it's very hard to change habits, right? For people who have taught a course a certain way, and practiced 30 years ago, are they really going to change? So I think there should be practice takeaways, or takeaways for practice in every course, and that should be baked into the learning outcomes for the course, no matter the course. If it's a doctrinal course, property law, contracts, torts. And so that's a fundamental change in how doctrinal professors may be viewing their subject matter expertise. I also think that a lot of what my colleague is discussing gets to the role that attorneys should be playing in society, and that is we need to be looking at attorneys as purveyors of the truth, and that requires truth-finding skills, and that requires some understanding of social science and how we are getting the information that we get. And anyone who's looked for information in Westlaw or Lexis knows that fundamentally it's a social science question, right? I have a problem. How do I find information that may support what I'm arguing for? But it goes beyond Lexis and Westlaw now, right? And it goes to the trustworthiness of information writ large. And how do we prepare students to use technology and to question technology when appropriate? I think we have to find a way to do that, whether it's a course or a seminar, I don't know. But I think in thinking about other forms of professional education, for example, medical education, they often have a culminating experience or test that is live in person with a panel of experts. And we don't do anything really that looks like that in legal education. We have this MPRE, multiple choice questions. You only have to get a small number right, and all of a sudden you're minimally competent to practice law. You got to pass the bar. But what about a capstone course that is experiential, right? That actually requires you to go before eventually a panel of people who pepper you with questions, and it's a three-dimensional type of problem. I think that could be a really interesting way to culminate law school. There's some law schools are looking at the third year and of doing more apprenticeship type courses in that third year, but most still aren't, right? Most still say a la carte, take whatever electives you want. We got to take some experiential classes, but nothing that looks like a really rigorous sort of culminating experience that has elements of practice right in it. And I think that's something that we ought to look at. The other is, what we want to do as deans and as faculty. We have to serve various different masters, and we're going to talk later, I know, about U.S. News, which is a real elephant in the room. And they announced recently that they're going to create a separate ranking of schools just based upon scholarship. And if you drill down on the details, it's only certain kinds of scholarship. That law review article that's so prized, that's not read by anyone in practice. And this, Chief Justice of the United States Supreme Court can make fun of law reviews in a room full of attorneys, and everyone laughs because it's true, right? Nobody cites them. Very few people read them. Seldom do they change the world. Okay, maybe that's controversial, but it is in part a reality. And I think,
Ooh.
This is a law review symposium.
This is sorry to my sponsors. But I've asked this question of our own law review at Gonzaga, which is, what's the future of publications look like? If you look at long-form journalism, take away the legal elements, very few people read it, and it's hard to find places that have it. And, you go back 20 years, there were more magazines that published long-form journalism. And now it's, what can I digest on my phone? What can I digest on my tablet? And it can't be very long. Law reviews, I'm very thankful to be publishing in West Virginia Law Review. And my article's not that long. It's like 10 pages. But, the gold standard is the 50 to 60 page law review article that is really a vanity, piece for the professor to get tenure or to, reify their status as an academic. That doesn't necessarily serve the profession, doesn't necessarily serve students. Why are we not encouraging more digestible, pithy pieces that might actually be picked up by practitioners and judges? Because the two are not mutually exclusive. I mean, academics can write short pieces. It's often much harder to write a short piece than it is a long piece. Long piece, you can just survey the landscape for the first 20 pages, and nobody even notices, right? In order to make your little small argument in the following 40 pages. Well, what if you try to condense all that into like 5 pages? And what if a law review made it known that that was what they were publishing, that's what they were seeking. And some are doing it in form of online blogs and that sort of thing. But I think we have to look at the sacred cows in legal academia and say, who are they serving? Right? Is this serving the interest of practice readiness? Maybe in some cases, sure, if it's, but even those articles that are a survey of the law that could be useful, actually, those are not the ones that our peers at law schools find exciting, right? Those are not the ones that are going to get prized in a promotion and tenure review. They want to see an argument that, it deals with a very small area of the law or a big area of the law, but they want to see a novel argument. And sometimes these novel arguments are never going to get implemented. And we sit around at academic conferences, and we all know that. And we just talk about them anyway. I think I'm getting controversial, but you wonder, right? Like if you look at other publications, like in medicine, for example, JAMA, their journal, Journal of the American Medical Association, it actually publishes, research that people can use. What's our equivalent for practicing attorneys? Is it a law review? I don't know. I'm not aware of one that has that as its sole mission. Is it the ABA journal? Certainly not. That's a short news snippet type magazine. So where can academics make their contribution to the profession, I think is an interesting question that we need to investigate.
Well, I'm going to briefly talk about what we're doing here at WVU as far as like tangible, concrete ideas and movements towards making our students practice ready. And then I want to open it up for questions. We're focusing on clinical and externship experiences. Our goal is to offer any student who wants that kind of experience at least the opportunity to participate in a clinic or externship.
We're all doing that. Come on.
I think the best way to learn how to practice law is to practice law, right? So this is probably, and our clinic experience has grown quite a bit in the last 5 years. We went from having 3 clinics to I think we have 9 different types of clinics now. We focus on simulation courses. So actually we have a business transaction drafting. I teach a patent prosecution course where we actually go through taking an invention from talking to the inventor. We do client simulations to going through the writing a specification, writing claims to actually I pretend to be the PTO and we go through this process of how do you get a patent. So I think we're trying to focus a little bit more on that. We have an initiative to try to look at how the law interacts. So in my property course, I've teamed up with the Leg professor and also legal writing, and we're going to try to make it more holistic so that you can see that law doesn't really work in a vacuum. It's, when we do law cases from a case book, they've been culled to one issue. That's not how the law works. You usually, torts touches on crim law, touches on civil procedure, touches on constitutional law issues. You need to know how this stuff works in real life. So trying to link all of these things together, it's not easy, actually, to try to give that kind of experience. Moot courts, right? We just had a success, so some of the people in the room have participated in our Supreme Court clinic, which just recently won one of their cases that the Supreme Court took on. So moot courts, again, is a great way to kind of get that experiential litigation. And then also one of the things that we try to do in our doctrinal courses is talk to practitioners. I know for my property law course, every year I call up like the big law firms in our state and say, what is it that you'd like our students to know about practicing the law? And sometimes I learn something new, like this Duhigg rule thing that I had no idea existed, but that's something that they said our students don't know and aren't prepared for, so I teach it in property law now. So those are some kind of more concrete initiatives that we're taking here.
And is this the promotional piece of the panel?
This is a commercial piece, right?
I'll just add one quick thing, and I'm not sure if this is controversial or not. It is controversial amongst certain law faculty, but I'll say it anyways. I think we're coming to a point where those traditional distinctions between clinician and doctrinal professor and legal writing professor are beginning to fall away, and a number of schools are pursuing that, to achieve something called unitary status. And I mention that because, what Dean Tu, referred to some of the initiatives you're doing, I think is relatable in the sense that even if a professor, such as myself, is teaching a doctrinal course like evidence, you have to learn evidence or crim pro, that doesn't mean that you are restricted from exploring ways to teach that material in certain interesting ways, right? To engage an experiential component to the classroom, perhaps, to incorporate simulation exercises and like a writing component, and vice versa, right? So in our clinic, at least, our clinicians, of course, handle really important cases, and I encourage everyone, all the students here, to take a clinic if you can. I don't remember much from my law school experience, but I remember the clinic I was involved with because there were real people with real lives at stake. But even from the clinical perspective, certainly that is a wonderful opportunity to think more broadly about legal policy and what the law should be.
I think you're right that there's this movement of bleeding the boundaries between clinicians, legal research and writing professors, and doctrinal professors. And I truly believe that the unitary approach is the better way. And that's what I said earlier, this sort of triple threat, trying to look for someone to teach, write, and practice, or who has capabilities in all areas. The problem is these lines are, long-standing. And many on faculties who have, particularly in the clinical ranks or the LRW ranks, have fought for status only now to see a younger generation of professors say, I want to do it all, right? They, well, hold on a second. No, I fought to get us at the table, and now you want to like go away from this. I'm seeing that, and it's, you know, the systems are built up to have these be very separate fields, and really they're not, right? You know, there's nothing that says a clinician can't teach a doctrinal class, or, you know, LRW person cannot, or the doctrinal person can't do something in the simulation field or experiential learning. And I think law schools and legal education will be better if we find a way to create equal status among all such parties. Maybe there's an area where you're primarily, most of your courses are in this area, but you're not viewed as, oh, that's the, you know, the LRW camp, and this is the, you know, I had a colleague who, at my previous institution, referred to LRW as the pink ghetto, because that was where women were relegated historically in the legal profession. They would only be able to teach in LRW. And it was seen as lower status and lower pay, and you know, he fought to change that, and it has changed at many institutions, but it has this legacy of being viewed as such.
With that, I'd like to open it up to questions from the audience. Stephen and then Kelly.
So earlier you were discussing the MPRE. Do you all believe that the bar exam prevents law schools from really focusing on practice-ready students, and that the diploma privilege at certain states, and West Virginia being one of them, would actually enable law schools to focus more on their students being practice-ready?
Yeah, I definitely think that more states ought to have the diploma privilege. And so, for sure, this gets to the real world versus law school thing, right? And the whole teaching for the test and multiple choice, you know, I think there's no getting around that there needs to be some standardized testing before one graduates, but some of that could be done at the law school level, right, to really certify one's readiness for practice. And I think that would help solve a lot of problems too in terms of the debt that's incurred after graduation but before practice, because we're seeing many employers are not hiring until they know you've passed the bar. If we could move that to actually align in some ways with graduation from law school, I think that'd be wonderful.
Right. So I would just echo that and say, when you're up in front of a judge, he's not going to give you a multiple choice quiz on why you think you may be right or wrong. I do note that I was talking to Kelly Testy yesterday, and they're thinking about using a different model, right, for the bar, which is actually parallel to the medical system, where it's a stage-wise thing, where in your first year you would take the first part of the bar, and it would go over the doctrinal classes, but also maybe is more theoretical in that that's how we teach our doctrinal classes. And then later on, as you get more specialized, then that may be tested in a very different way. And I'd love to hear from Kelly about how you might go about doing that. But to me, that's a much better way. It's much more rational, and it also allows you to specialize, right? So you can, just as in medicine, where, you know, if you're internal medicine, that your test is going to look very different than if you are a dermatologist, right? So maybe if I'm going to go into patent practice, that should look very different from patent practice on the transactional side. That's going to look very different from if I want to go into litigation or constitutional litigation. Did you have any comments on that, Christian?
No, I just absolutely agree. I mean, the only thing I would add is certain aspects of the current bar do have the potential to distort the learning experience, right? I mean, for my students at least, I'm not interested in your ability to memorize a black letter legal principle that you glean from a case. I'm interested in how you can analyze the broader issue at stake, but I absolutely agree.
So I'd be happy to talk about the bar exam, but I really came down here to defend the law review.
Okay, I like that.
So what I wanted to suggest is that I actually love your conversation, and the idea of a medical model, whether for bar exams or for the way we think about faculty, I think has a lot of promise. So if you think about doctors, they're in teaching hospitals, they're practicing medicine, they're teaching students, they're doing serious research, discovery, and making great contributions in scholarship. So there really isn't any reason why a law faculty member couldn't be more in that model. But I do think that there's a really significant role still for scholarship because, you know, when I speak to a lot of lawyers and practitioners, there's often not time to think about some of the big issues that one needs to think about. So I don't think the problem is in scholarship itself. It's more to me about the quality of scholarship and the lack of, in many examples, answering questions that really need to be answered and that would really help advance law and thinking. But I do want to remind us all that one of the things that does happen in scholarship that I think is so important is that it's often where law starts. So it isn't every article, but there's some really significant ones. You know, you think about Brown versus Board of Education, some of that thinking started in law review articles. You think about Catherine McKinnon and the tort that became sexual harassment, that started in a law review article. So, but I do think there's a great way we can bridge some of this. And then finally, I would just say that one of the real conundrums I see, and I'd love to hear your comment on, is when you talk about skills education, law graduates do so many different things. How do you address skills education in the context of a student body that might go into technology, healthcare, law practice, entrepreneurship? What skills matter?
So if I may comment on both of those, I agree with you on the scholarship comment. I think what I'm getting at is there's an empirical issue, which is we have something like 900 law journals that seek to publish one or more times a year, in some cases 3 or 4, and each issue 4 to 6 articles. And a lot of this stuff is frankly garbage. And so it's not really difficult to publish in a law review or a law journal. It's a preordained conclusion. You will get published somewhere. The bigger question is what's quality and what's not. And I think, frankly, some journals ought to close or merge. And that's not happening, right? We are at law school saying, oh, come here because we have 20 specialty journals, right? But if you actually peel back the layers, some of those specialty journals should be a blog. They should be merged with another school's specialty journal in that area. They shouldn't all be worshiping a 1990s sort of model of if we build a journal, then therefore we're doing good work in this area, because that's not really true in many cases. On to the skills question. I think that there are certain skills that transcend practice area that law schools ought to be teaching, and most are not. And those are leadership skills and business skills. And I think one needs some mixture of both, whether you're going to be a public defender or work for, Skadden, and everything in between. And I'm not setting those on some value scale, but just in terms of what those practice environments look like. Leadership is key. And I think law schools draw leaders naturally, but not everyone has natural leadership tendencies or qualities, and yet it is a skill that can be acquired. And I think the quicker one becomes familiar with what leadership entails and embraces it, the better they will do whatever their walk in law, whatever their particular field. Business skills also, right? So some of what we're talking about, I think there's no getting around that lawyers today and into tomorrow are going to have to be entrepreneurial. They're going to have to know how to develop clients, retain clients, keep bosses happy, run a practice. Maybe, I think more than ever before, we're seeing some lawyers, their first job is hanging a shingle. And I've had students say to me, I've learned nothing in law school that prepares me to run my own practice, which is what I'm going to be doing. And so I think law schools need to own up to those skills and teach them in some concerted way.
I would echo what Dean Rooksby had said. I also agree with you about, I'm biased, but I agree that the law scholarship, theoretical law scholarship is really important. And I'll go back again to my first love, which is biochemistry, and tell you the story about Earl Sutherland, who his research was understanding why some rats are able to open their eyes 2 or 3 days earlier than other rats. And he isolated this factor called epidermal growth factor. And when he puts it on the eyes of rats, they open up 3 or 4 days earlier. What kind of research is that, right? Well, it's the foundation of all cancer research now. This is signal transduction and how cancers are able to grow kind of out of control. We would have never gotten any of that if we didn't have basic research. Later on, he went to win a Nobel Prize for this discovery. And again, you might look at it from the outside and go, why are we funding research on trying to understand why rats open their eyes 2 or 3 days earlier? This is a waste of money. But, you know, in the end, it really did change the way we think about cancer cell biology. Isabella?
Hi, thank you so much for being here today, first of all. My question is about how do you incentivize law schools to move toward change, to incorporate experiential learning into the curriculum? Do you see that as something that could potentially come from the top down, such as the ABA requiring experiential learning benchmarks throughout legal education? Or do you have any other ideas about how that could maybe be incorporated to push towards change in the future?
I just want to take a
sorry.
first stab
Yeah,
at
go
this.
ahead.
I think that it's happening with employers, right? If we can't employ our graduates, we're not going to be in business for very much longer. So I think it whether we like it or not, is coming top down, right? Because we need to find our graduates jobs.
I think that's coming outside in. I think top down is the ABA, as you mentioned, and I would hesitate to suggest that we need enhanced ABA oversights. I think one could question, this is a topic for a different panel, but what should be the ABA's role in regulating legal education? And are there other entities or organizations that would do it more effectively? I'll stop there.
Yeah, I mean, that's a great question, and certainly, you know, there are many ways to approach this, but one way, at least that I've been exploring at my own school, is about changing the institutional culture the best you can, right? To obtaining buy-in, to obtaining, you know, broader consensus among the faculty, but also the students, trustee members if they exist, alums, and so forth, that this is something worth valuing, right? It's worth it to redo your class lecture notes for evidence because you want to incorporate a novel experiential component, and that's a process. But you know, I think you know, as law schools have been trying to find innovative ways to respond to changes in legal practice, there is increased willingness to explore new ways of teaching.
May I just say one thing? What we're really talking about, I think, here is change, and what is an organization's receptivity to change. And often it's the case that it's the ones that have the most to lose that are most motivated, right? So you're seeing some innovative things from some schools that are, frankly, at risk of going out of business. And for other schools that are comfortable, the need to change seems less apparent, and the potential effects might give them some pause, because they say, well, we're already okay, so let's just keep being okay. It's worked for this long, it'll continue working.
Hi there, thank you guys so much for coming and really talking to us about these practical experiences. I was curious if you guys could speak on maybe distinguishing between opportunities for those who are interested in litigation, but also those who are interested in more transactional opportunities in terms of practical experience.
So I'm really glad you mentioned that, because I think this goes to, again, how legal education doesn't change. If you actually look at most law schools' curriculum, it is a litigation-focused curriculum, and it privileges litigation. It presumes the highest and best use of an attorney is litigating in court. And of course, the reality is most people aren't litigators. Most cases do not go to trial. Most cases settle. And so we're not teaching in law schools often the transactional skills or, frankly, the mediation skills and the other types of restorative justice type skills that really attorneys need to be trained in doing, and it comes down to communicating. But we think, right from the case book, the privilege of the case book, and everything is a litigated case where there's a winner and a loser. right? It's all set up for this battle that, yeah, battles go on, but a lot of things get settled short of the battlefield. And we're not really designed to, in most cases, prepare students for that reality. It comes down to changing courses, right? Changing the whole setup of the curriculum.
Right. You know what the cases get litigated? It's when the transactional people F it up, right?
I don't have much to add to that, but as Jordan knows from an earlier discussion, it's hard to predict what your career is going to look like, I think especially now. And I started off thinking I was going to be a transactional attorney. It sounds so interesting and, you know, like cosmopolitan, you know. And I actually, nothing against those folks who do that sort of work in the room, but I couldn't stand the work. And so I tried, you know, my hand at a few different things, and eventually I went into litigation and IP and so forth. But that's to say, I think law school can provide you with a general you know, background of skills and experiences that hopefully you'll be able to utilize moving forward in your career.
Thank you.
Mm-hmm.
Hello, I hate to upset anyone by using this word that begins with an F, but finals. I was curious as to whether or not you think that traditional finals and that process actually prepares you to be practice ready. And if you could comment a little bit more about maybe the future of finals as well.
I think it prepares you to be bar ready. And I don't love finals, but so long as the bar exam continues to be a 2-day closed note endurance effort, I think there is something to be said for a high stakes finals type period. And I say that as someone who taught torts. I didn't love that fact. I didn't like the forced sorting that goes on. But that is what the bar exam is currently consists of. So I do think it serves a purpose.
I would agree with Dean Rooksby. I would also comment, what would you call a 2-hour closed book multi-issue exam that you have to write down legal theories? If you were doing this in real practice, what would we call that? Malpractice, right? So this is fairly artificial. In real practice, you would have resources available to you. You would have to do your research. You'd have to spend more than 3 or 4 hours on this kind of stuff. But with that said, this is the way our bar is set up. So does it make you practice ready? Well, kind of, I guess. It lets you at least spot the issues kind of very quickly. Would I want a lawyer to counsel me with just that kind of preparation? No way. No way.
And I agree. I mean, you know, I think there is some bar-related value to midterms and finals, although you also have flexibility in how you evaluate a student's grade, especially in certain non-bar courses. So one course that I teach is immigration, and we essentially, or I use, a capstone exercise at the end to evaluate a student's understanding of the material and ability to apply that material to a set of facts. And so it's a mock removal hearing, deportation hearing. We involve actual actors to serve as witnesses. There's witness examination. They have to handle documents and so forth. I'll stop there. But some courses do have the luxury of experimenting with different ways to evaluate student performance.
Hi, thanks for coming.
Maybe one last question here, because I'm looking at the time. And
Okay, so in this desire to inject practicality into it, like our doctrinal courses, do you foresee any changes to, you know, most schools having the same near the same curriculum for the first-year students in an effort to, like, if a student comes in knowing they want to practice something business-related, maybe not having them take a criminal course and studying that separately for the bar exam?
you want to take a stab? Okay,
yeah,
I would say
but-
no.
yeah,
There's a reason why. First of all, you may come in with the idea that you're going to practice X in X area, and then you may realize that you absolutely hate that area. And you may realize after taking a crim law course, you know, that this is your new passion. And I think that it would be bad to come in that narrowly focused. And not only that, again, a lot of areas of law touch with other areas, right? So if you're thinking, all I'm gonna do is litigation and torts, and you don't understand the criminal aspect of it, you're really missing out on a lot of doctrine, a lot of public policy, and the same arguments that you would make in a crim law aspect may apply in a tort law aspect. And if you just said, I'm never going to practice this kind of area, you would miss out on that.
I agree. I think the first-year courses provide a common language and building blocks for future growth and development. And if you look at other professional schools, it's like, you know, everyone takes organic chemistry in medical school. They take anatomy. There are certain basics on which everything else, you know, it gets built. And so I don't foresee them going away. I think a follow-on question is, do we need a torts professor, a contracts professor in every school, right? Or is there some economies of scale that could be realized through online learning, for example? This is the whole concept of, you know, MOOCs. If we know that there's the best contracts professor at school X, can we get that professor to provide the instruction to more than just students at school X? Might there be some benefit to doing it that way? I mean, what I find it amazing, if you look at in these areas how many different case books there are. I mean, it's like, you know, 21 different varieties of often the same kind of material. Now, maybe there's a best one or best couple, but if there are, shouldn't we just say use those? I don't know.
All right, well, I'd like to thank our panelists.